Samvidhaan, Hamara, Swabhimaan. So the success of Constitution for the last 75 years shows the success of democracy in Indian plural society. So actually our Nageswara Rao get the importance of the Constitution and the contribution of the constitutional makers and judiciary also from time to time regarding the constitutional functioning. So actually the members today, all the newspapers gave a lot of importance to the Constitution Day celebrations. If you refer the Eenadu, it gave some 2 pages full, like a complete picture about the constitutional making process, important stages and important judgments, contribution of judiciary, as Nageswara told about Balakanath case. All these were referred in the Eenadu, and all the papers contributed and special essays were also written. So in one of these photo is there regarding Constitutional Drafting Committee which prepared the Constitution. In 1947, August 29, this Constitutional Drafting Committee was constituted. It worked, as Nageswara told, 2.5 years more. Then the members provided this, particularly D.P. Kaitan, Syed Muhammad Saudullah, B.R. Ambedkar, Chairman, Alladi Krishnaswamy Iyer, B.N. Rao, Danagala Narasimha Rao, the constitutional advisor. On behalf of the drafting committee, he visited several countries and he met several people. In the process, he met American judiciary, particularly one of the important judge who promoted from professor. In America, it was a practice. Law professors can become the judges, judges can become the professors. So professor is given more value than any other post in the public life of country, because corruption plays zero role. That's why the value on the basis of the knowledge and on the basis of the contribution, the people are valued. So here, B.N. Rao got several advices regarding the framing of Article 19, which guarantees the freedoms. He advised, in American Constitution there were no restrictions, which paved the way for some ambiguity. So you specify these restrictions. That's why Indian Constitution guaranteed the freedom. Originally 7 freedoms. Now we have 6 freedoms. Freedom of speech and expression, freedom to form association, freedom to move throughout the territory, including go abroad. So the corresponding restrictions were provided. So you have freedom. Your freedom ends where others' freedom starts. So because you have freedom of speech, you cannot use that freedom of speech at your will without affecting the security, tranquility and the rights of the others, defamation and other aspects. So your freedom is not absolute. It is subjected to the restrictions. Those restrictions are reasonable restrictions. So that's why Article 14 guarantees equality. Equality has no restrictions. So anything done for the promotion of the development of the society or individual, that is part of equality. Equality has no restrictions, whereas your freedom has restrictions. So that's why, as far as Indian Constitution is concerned, we know we the people of India, having solemnly resolved to constitute ourselves into a sovereign democratic republic originally, after 42nd Amendment, sovereign, socialist, secular, democratic republic. Professor Nageswara Rao dealt the problem regarding the recent judgment of Supreme Court which approved the words, 3 words were inserted in 1976 with 42nd Constitutional Amendment, socialist, secular with integrity. Of course, that's why the possibility of adding a word to the preamble is possible. But nobody can remove the word because violating the basic structure. If any single word of the preamble is removed by way of constitutional amendment, if it violates basic structure, it is not valid. That's why to fortify the spirit of preambular declaration, any word can be added like socialist or secular. But once those are added, it becomes common hodgepodge. So we cannot separate those values which are prescribed in the preambular declaration. Say for example, justice, political, social, economic, equality of status and equal opportunity, liberty of thought and expression, faith, worship, belief, and to promote among them all fraternity. So justice, equality, liberty and fraternity. On these 4 basic pillars, the Indian Constitution was built. So in order to promote these values, we have fundamental rights. We have direct principles of state policy. So at the time of making of the Indian Constitution, so our constitutional makers took the experiences of the other constitutions. Before Indian constitutional makers, as Professor Rao told, the American constitutional experience of 150 years was there before the constitutional makers. So they took the advantage of important decisions. So judicial review, which was first developed by Justice Marshall in Marbury versus Madison, the judgment of that judicial review, concept of judicial review was indirectly encrypted into the constitutional system by way of incorporating 13 clause 2. The law which is inconsistent to the provisions of fundamental rights is void. But who can declare? The judicial review of legislative process and executive process is given in Article 13, Clause 1 and Clause 2. So as Rao told, Article 32, if Ambedkar told, if anybody asked me, what is the important article without which there is no meaning of constitution? Without having any hesitation, I can refer Article 32. Because Article 32 confers the duty on the apex court, Supreme Court of India, to protect and enforce the fundamental rights. Rights are given to the people. Every right has to be corresponding duty. Without duty, there is no meaning of right. I am talking that I have right. So unless somebody honors my right, unless the duty is imposed on somebody else, there is no meaning of conferring my right. So rights are given to the people. The corresponding duty was given on the responsibility shouldered on the apex court through Article 32. So directive principle, of course, fundamental rights were taken from American Constitution, Bill of Rights. Directive principles were taken from Ireland Constitution. Parliamentary democracy was taken from Britain Constitution. From Australian Constitution we had Canadian Constitution, we have federal setup. Some of the provisions of federalism were taken. From USSR Constitution in 1976 particularly, fundamental duties were inserted. Recently a discussion went on in Supreme Court. What was the contribution of the Parliament during emergency? So all the provisions, all the amendments brought during emergency were not bad. Some are very, very important as these values were inserted. So that's why when emergency was imposed, Justice Khanna's judgment of minority judgment of habeas corpus, that's why when we re-examine the contribution of legislature, so through various constitutional amendments, several times the constitution was made viable. Constitution is not a static one. It is a dynamic one. Constitution is not a dead tree. It is a living tree with a lot of roots, branches, leaves. So a living constitution can be compared with a living tree. So that's why the Indian Supreme Court, of course, wherever constitutional amendments were brought, of course during Indira Gandhi time some problems were there, but after she became Prime Minister again in 1980, she never interfered in the judicial process until her death. So actually when Keshavananda Bharati was there, the government planned to review the judgment and 15 judges constitutional bench was tried to be constituted. Then in the process Justice Krishnaiyer was invited for breakfast by Madam Gandhi. Then Krishnaiyer advised Madam Gandhi, today you may be here, tomorrow you may not be there. So basic structure is the root cause for the success of Indian constitutional function. So he never tried to make an attempt to dilute the concept of basic structure. Then she dropped the idea. Even when Vajpayee government tried to reconstitute the constitution and appointed constitutional review committee, Justice M. N. Venkatachalaya accepted chairmanship under two conditions. The review committee should not be asked to review basic structure law. It should not be asked to replace parliamentary democracy. Subject to parliamentary democracy, subject to basic structure, Constitution Review Committee can function. That was the condition he put. So we had parliamentary democracy from England Constitution. But whereas, that's why there was a comparison. Indian Constitution is compared with a lady. The lady has saree like fundamental rights, jacket like, blouse like direct to principles. And all these are taken from different constitutions. A vanity bag like fundamental duties are from USSR Constitution. But even though the Indian Constitution was influenced by various other constitutions, it was made to make it suitable to the conditions of the country. So the success of Indian Constitution, we can proudly say, is the success of Indian democracy. So the contribution of Parliament, that's why in those days, when Madam Gandhi was trying to bring a lot of amendments, Palkiwala jocularly commented, if executive was given unlimited power, Indira ridden executive power is allowed to amend the constitution, they can amend, mend and end the constitution. So in the name of amendment, they may end the constitution also. So the power of amendment should not be given in absolute manner to the parliament. So Balaknath accepted. Of course, it is not a place to discuss the nuances of all these things. But today we are recollecting the contributions of the constitutional makers, the contributions of the Indian legislature, contributions of Indian judiciary, Indian executive for the development of the country. Of course, now we are talking about, we are in the fourth economy, I think. After America, China, we are the third. Isn't it? Even we crossed Britain also. Because it was a small country, because of its exploitation of India, now so far now it was survived in the international trade. So by 2047, India can become the world's second biggest economy. So for which we are trying to work together, and as far as the contribution of judges, of course, so many judges may be there appointed by the different constitutional agencies, particularly H.R. Bharadwaja once made proudly, 90% of the judges are being appointed by me. The reason was, in those days, whoever the list sent to the president, before approving the appointment orders, president simply sent a copy of the appointed judges to the Supreme Court. In 1993, because of this, judges transfers 2 cases. One is S.P. Gupta. Supreme Court interpreted consultation is not mere consultation. It is effective consultation. Effective consultation means the Chief Justice has to be consulted in an effective manner. So when he is consulted, he has to constitute a collegium. He cannot give an independent decision. So for High Court judges appointment, first 3 judges. For Supreme Court appointments, 5 judges are there. First 5. So all these are there, whoever may be. That's why Ambedkar long back warned, however good a constitution it may be, it may turn out to be bad if the people who are called to work upon it are bad enough. However bad a constitution it may be, it may turn out to be good if the people who are called to work upon it are good enough. So the people who are called to work upon it, whether a legislator may be, a judge may be, or an executive may be. So if they are good, whatever bad institution it may be converted to be good. So 75 Constitution Day celebrations is not a small thing. So India survived. Of course, if you are aware of the history, particularly at the partition time, Britishers thought that Indians could not make their own constitution. So they proved, Indians proved that they are able. Actually, in order to write the constitution, Ivar Jennings was consulted by Nehru and others. It is Mahatma Gandhi who suggested that B.R. Ambedkar should be there in the drafting committee. Actually, Ambedkar was elected from the Punjab part, where it was separated to Pakistan. So his membership was lost. Then, on the insistence of Mahatma Gandhi, an elected member of Congress party from Bombay resigned. In that by-election, Ambedkar was elected and co-opted. So that's why T.T. Alladi Krishnaswamy Iyer made a famous comment regarding the contribution of Ambedkar in the constitutional making process. So even though several members were there, one member died, one member left to America, a foreign country, and one member suffering with some ailment. So it was, the sole responsibility was shouldered on B.R. Ambedkar. So it was his major contribution. In the Constituent Assembly debates, if you observe, Ambedkar praised B.N. Rao, that he is the major contributor of making a constitution. And B.N. Rao also praised. That's why even some doubts are there. And who is, but it is Ambedkar who took the opinions of all the people. And even though he was an anti-congressman, he accepted the draftsmanship, chairmanship of drafting committee with the sole intention that he has to provide a responsible document. So as Nageswara Rao told, Constitution is not a mere legal document like other legislations. It is a political document, economic document, and social document. The political aspirations, economic aspirations, and social aspirations of the people are reflected in the constitutional process, whether it is Indian Constitution or Constitution of any other country. So Constitution is the reflection of the people's expectations. So how equality was interpreted, how liberty was interpreted, how life, in the initial stage, life was interpreted as not mere animal existence. From that stage, life was further broadened life with human dignity, life with livelihood or decent life. So now life with human dignity. Dignity is more important than any other economic value, any other political value, any other social value for a human being. That's why in privacy case, Swami case, Justice Chandrachud referred the word dignity more than 70 times. The reason is human dignity is the fulcrum of all the human values. After all, when a value is recognized as an important concept, it becomes right. So, originally, political and civil rights are given in the fundamental rights. Social, economic and cultural rights are given in the directives. But both are important. So, as Nageswara sir also told about the Minerva Mill case regarding the balance between fundamental rights and directives. So, balance is not possible. So, that's why Dworkin was able to distinguish between strong rights and weak rights. In a society, some rights are strong rights, some rights are weak rights. Then, as long as there is balance between these two rights, say for example, environment and development, sustainable development is the balance. If balance is not possible, in one occasion, environment is to be sacrificed. In another occasion, development is to be sacrificed. So, like that, the directives and fundamental rights, balance is to be maintained. Both are supplementary and complementary to each other. But if balance is not possible, one interest should be sacrificed. So that's why at least some of the directives must be read with fundamental rights in the recent Supreme Court approach towards these two. Anyway, regarding the Constitution Day celebrations are concerned, so today the entire nation is very jubilant regarding the success of Indian Constitution. The reason is it was made viable. It is not static. So whenever there is a danger to the society, it can be brought. So there are reasons. Indian Constitution was made with strong center bias. So with undestructible center, with undestructible center and undestructible states. Originally 50 states came together to form the American nation. Even now, after 245 years, 50 states are continuing. But in India it is not the case. So in order to make strong center, Article 3 was provided. So Parliament has power to organize, reorganize the existing states. That is what we witnessed in the recent bifurcation of the Andhra Pradesh into two states. So that's why Constitution is important. As long as we promote the constitutional values, as long as we have understood the constitutional morality, constitutional legitimacy, all your values, all your legitimate expectations can be realized through the constitutional process. So for which judicial process makes a lot of tremendous contribution. The success of Indian Constitution should go to the contribution of judiciary. As long as judiciary is strong, as long as judiciary is independent, there is no danger to the Constitution of India. Thank you very much for giving.